10 common misconceptions that you as attorneys do not want to accept as an underlying premise when you're dealing with a defamation. Tell your side of the story by posting a response below. Don't do that. Be very careful about recommending to the client that they do so. What that does is that increases the popularity of the post. It is a technique that is used by individuals who are defaming a company to keep a post relevant. It's called bumping. Secondly, second misconception, respond once forcefully to the lies and then ignore the situation and counter from that point forward with positive initiatives. And this is the old public relations. And here's an interesting one. If the statements are opinion and not fact, then you have no actionable defamation. I'm here to tell you, you do have actionable defamation under certain circumstances when you read what appears to be opinion. It's an issue that is going to receive more attention, but I do believe the idea that you have to absolutely have a fact asserted is one that is going to, is changing and has changed as we speak. The fourth misconception about dealing with online defamation claims is that there are so many lies on the internet about my company that I could never show what damages are attributable to any one particular attack. I'm faced with the scenario years ago in which, fireworks displays exploded and no one could figure out whose fireworks caused the problem because they're all gone. Came up with this idea of market share liability. I suspect that's where the courts will end up in situations in which you have quote-unquote mobosphere attacks and you're unable to identify specifically which individuals caused damage. The fifth is the premise that gripe sites are protected by the First Amendment and free speech. That's not really accurate in its totality, because most gripe sites, if you look at them, are economically motivated. They are a commercial enterprise in one way or another.